13 minutes past 8. You're joining us on the Morning Fix. This morning it is Trial Tuesdays, and that means we've been joined with CMS Daly Inamdar, and we'll be chatting all about succession law.
Yes, that is right. We're on a call with Lilian Lofty from their Nairobi office and Nishit Maru from CMS in Mombasa. Let's just jump right in with the basics. A lot of people talk about having a will. I know I have said that so many times to my dad, make a will. Getting one. But what exactly is a will? Nishit, maybe you can take this one.
A will, simply put, is a legal declaration by a person who, of his wishes or her wishes, of their intentions regarding the disposition of his or her property after the death, duly made and executed in accordance with certain provisions of the law. The will essentially dictates your wishes or intentions with regard to your monies, your possessions, your properties, and how it should be distributed or shared after one passes away. What listeners should also bear in mind that if you don't make a will, then it is the law that will decide for you how your estate shall pass on to your immediate or even extended families in order of priority basis pursuant to lineage in accordance with the Law of Succession Act.
Okay, so that makes sense that the law has some provisions in case you don't make a will. But in that case, why would someone actually go ahead and put in the effort? Maybe Lilian, you could tell us, what is the importance of a will?
Now, if I take you to a quote by Sun Tzu, who's quoted as saying the greatest victory is that which requires no battle. So by preparing a will, you would provide certainty to the people you leave behind. A will would, for instance, prevent disputes amongst your intended beneficiaries as you provide certainty to those you've left behind. A will would enable you to, for instance, maintain control over the properties you have acquired over your lifetime.
I really love that Sun Tzu quote. The greatest victory is that which requires no battle. That's a great reminder that you should start getting your affairs in order while you have the time so you avoid conflict later on. Lilian, if you don't mind, could you also explain to us what a living will is? I've heard the term being thrown around, but not sure exactly how it works.
One may have what is called a living will. This would provide guidance as to what you wish done in the event you are still alive, but unfortunately incapable of dealing with or making decisions in the day-to-day running of your affairs, where, for instance, one is diagnosed with dementia.
All right, I think I like these simple explanations. I'm getting to realize exactly. I didn't even know that there's something like a living will. But you know what? That's what we do here on Trial Tuesdays. There's so much more to learn with CMS Daly Inamdar, so keep it here. This is Radio 44.
It's just another sad love song, Beiji.
Gurundava with Munde Marge. Song is a pretty good one for his 2021 vibe, but Gurundao might be in some hot water after Juggy D kind of exposed him on his Instagram stories just one day before Juggy D himself got arrested.
Exactly. Allegedly arrested.
Allegedly arrested. Yes, Thank you for having my back legally. That's exactly what I like to see on Trial Tuesdays. We're in conversation with CMS Daly Inamdar. We're joined virtually, actually, by Lilian Lofty and Nishit Maru all the way from Mombasa, and we've been talking about succession law.
Yup, and we have broken down what a will exactly is. But Nishit, could you just tell us about how a will actually works? I know there are different types of structures or ways an asset can be passed down, but if you can shed some more light on this.
There are many different ways in which one may choose to distribute their properties. Amongst these ways, one may choose to give a specific gift. Okay, now a specific gift is a personal gift, a gift, for example, a piece of jewelry, a piece of watch, or a car. One may choose to give this to a specific person who's named in a will. One may choose to give a money gift, which is a pecuniary gift, again, of a specific amount to a specific person who's named in a will. One may choose to give either their entire property or a portion of their property, which is identified under the will to a charitable institution of their choice. And it doesn't matter. It's a matter of choice. It can be either to a charitable institution that deals with preservation of animals or preservation of the environment, or one that takes care of children with this people with a disability. One may also choose to give a residual gift under a will. Now, a residual gift is a gift of the remainder, whatever that remains after the specific gifts or the pecuniary gifts have been given out, or in instances where a maker or a testator chooses to give his entire estate to a sole beneficiary. Then in that case, that person becomes the beneficiary of the residuary gift.
There are a lot of terms to break down there. So thank you so much, Nishit, for shedding light on the different structures. CMS deals with this on a daily basis. So they are truly the experts. So if you have any questions, please message us 0758 123 444. Up next, we've got a collaboration with Mr. Easy and the Birmingham Boys. That's Lotto Boys playing for you on The Morning Fix. This is 91.6 FM in Nairobi. Radio44.co.ke worldwide.
Yeah, I want to let you know.
Kisto of the brand new movie Ruhi. Have you watched it?
I've watched half.
You abandoned it halfway.
Yeah, it was really bad.
I'm guessing I shouldn't watch it in that case. Don't. That is your movie review on The Morning Fix. But today is Trial Tuesdays. We've been talking to CMS Daly Inamdar, particularly with Lilian Lofty and Nishit Maru, who are experts in the field of succession law. And we have a couple more questions for them.
Yes, we've spoken about how important and critical wills can be, but we've also seen some families end up in court battles that go on like forever just because of a poorly drafted will. So Lilian, maybe you could take us through the side effects, or rather the effects of a poorly drafted will.
As mentioned earlier, the importance of having a will is to provide clarity to those who are left behind. A poorly drafted will would lead to ambiguity or inconsistency, and there's a possibility of the will being rendered invalid, either because it did not conform to legal requirements or is incapable of ascertaining the intention of the testator. A poorly drafted will could also bring about fights as amongst the intended beneficiaries. In this regard, we've read in the papers of incidences of families being embroiled in court battles over their estate assets that drag on for years, some as long as over 30 years. Where there has been such long court proceedings, there have been instances where an intended beneficiary passes on, and as a result of which the process would be further complicated, as the court would now be required to deal with the estate of the recently deceased beneficiary. A poorly drafted will could also bring about fights as between intended beneficiaries and those that believe they may have a claim on the estate. For instance, those who had been assisted in one way or another by the deceased. Now, where the parties are not able to agree on the interpretation of a will, the parties may end up tied up in litigation, requiring the courts to determine what the intention of the deceased may have been, since the testator is no longer available to shed light on the matter. Ultimately, a poorly drafted will would result in delays in the disbursement of assets and the winding up of the estate.
I'm getting stressed listening to all the effects. But Lilian, I'm sure you can agree that this is 100% avoidable if you just draft the will correctly. So do not fall into the hole of just, drafting it anyhowly, and then you're actually leaving people with a bigger problem to solve. Yeah. But I think, Bhargav, you're convinced to get your will drafted.
For sure.
And I'm also convinced.
There's nothing though, management, please listen to this.
Yes, we can up our salaries and increase our will beneficiaries, what they get as well. But Nishit, maybe you can shed some light. We have decided to draft our wills. How do we go about this?
Well, CMS, both offices in Mombasa and Nairobi, run a full-scale department that deals with succession planning or estate planning. Both Lilian and I, Lilian, who's based in Nairobi, and I in Mombasa, have clientele who time and again seek our services when it comes to estate planning. Now, in terms of the will making process, any person who is of adult age and of sound mind and understands the implication of making a will can make a will. Okay. A female person, whether she's married or not, has the same capacity to make a will. The only criteria that the law provides is that at the time when the person is making a will, it should not be delusional, should not be intoxicated, should not be under threat or coercion or undue influence.
There you've heard it from CMS Daly Inamdar. If you have any more questions about succession and wills, do get in touch. We'll be with them all the way till 9 a.m. This is Radio 44's Trial. It is 10 minutes to 10 here on The Morning Fix. We're joined virtually by CMS Daly Inamdar, and we're talking all about succession law.
Yes, and now there are a lot of misconceptions around wills that might scare people off taking the time to actually draft a will properly. Lilian, could you dispel some of the common misconceptions when it comes to wills?
There are some misconceptions we've come about wills being prepared. One, and a very common one, is that to discuss the contents of or prepare a will is to invite death. We've come across this misconception, irrespective, when I'm dealing with people from different faiths or different religions. But what we need to remember is that death, unfortunately, is inevitable. There's the assumption that everything will go to your spouse or someone you've been living together with. I alluded to this earlier. That another misconception is that all your children would get equal shares, but this is not necessarily the case, as there may be that feeling amongst the children that maybe one got more than the other in the lifetime of the testator, and as such that when they're coming to distribute the final estate, that the others should get more than one or other beneficiary. Some have a feeling that wills are only for the very wealthy, or that the cost of preparing a will is too expensive and it would take too long. There's the other misconception that if I don't include an item in my will, I'm hiding it and protecting it from, any other person that may come about to challenge my will. And that again now would make the asset now fall into the rules of intestacy or as an unclaimed asset.
There are quite a number of misconceptions, but there's one I personally have, and it's around the confidentiality. A lot of people think that, you're setting out to write your will. That means you have to air all your laundry for everyone to see. Nishit, maybe you can tell us a little bit about the confidentiality aspect of a will.
The disclosure of the contents of the will is at the discretion of the maker until his demise. Okay? As I said earlier, a will only becomes effective upon your death or the maker's death. And therefore, if the maker of the will chooses not to disclose the content of the will to any of his family members, he can keep it entirely confidential. Okay? There are many instances where we are approached by clients who request us to hold on to their wills under seal. Okay? So we keep them safely away until the time of his or her death, when we will hand over the will to the executor named in the will. Similarly, the maker of the will can choose to keep his will safely sealed up until the time of his death, when the will be opened up and the contents revealed. What is important to know is that upon the death of the testator, once the will is propounded in court, it becomes a public document. And therefore, its contents will no longer be confidential, but will be available, to the public generally.
Well, there you go. If you had any questions about confidentiality and wills, we hope this has cleared it up. A huge thank you to CMS Daly Inamdar partners Lilian Lofty from Nairobi and of course Nishit Maru from their Mombasa office for joining us this morning.
Yes, thank you so much. It has been super educational and I'm definitely going to draft my will. Bhargav, do you want to come along?
I probably will.
I might even consider putting you in the will
Thank
if you decide to drive me there. I'll leave you some money for fuel.
Done.
There you go. Remember, you can join us every Tuesday with CMS Daly Inamdar on Trial Tuesdays. This is Radio 44's The Morning Fix.